Okay. Welcome everyone in the webcast audience. I'm Terry Maggedy, chair of the Elder Law Committee of our Trust and Estates section for the Beverly Hills Bar. And the first thing we do, of course, is to acknowledge our sponsors, because they're the ones that really help the bar, do what it does through the year. And so, we have great appreciation for them. And our first sponsor is Nancy Sanborn and Brian Joy from Berkshire Hathaway. They're brokers who deal in real estate matters that are all in our space: conservatorships, probates, trust, real estate related to older people. Thank you, Nancy and Brian and the Sanborn team. And our next sponsor is here to address you herself, Orit Gadish.
Thanks so much. Oh, thanks, Terry. Hi, everyone. I'm Orit Gadish, broker and owner of Geffen Real Estate, specializing in representing trustees, executors, and administrators. I'm excited about today's presentation. I'm American, but also an Israeli, and also have family living there. It's a small and beautiful country. You might wonder, what is it like working with an Israeli? We're direct, straightforward, honest, tough negotiators. We're sabras, a prickly pear, tough on the outside, but sweet on the inside. If we haven't had a chance to connect yet, please reach out so we could either get together for coffee or a Zoom call. My contact info is in the chat box. Enjoy your program, and back to you, Terry.
Thank you, Orit. And our next sponsor is Marcine Klein and Glen Oaks Escrow. As with all of our sponsors, these are folks who operate right in our area of specialty: escrows for probates, for conservatorships, for trusts, very complicated transactions. Thank you, Marcine and Glen Oaks Escrow, for being our sponsor. And our next sponsor is a title company who works in our area, California Title Company. Title company who, as they say in the ad there, works with trust and the trust and probate community, especially geared for the transactions that we're dealing with in real estate, trust, conservatorships, probates, and those sorts of things. Thank you, California Title Company. And our last sponsor, last but not least, Manufacturers Bank, a bank that is also operating in our space. A bank that's very aware of how conservatorship accounts, trust accounts, probate accounts, fiduciary accounts operate, and make it easy for those of us who work in this field and to help with our banking needs. So thank you, Manufacturers Bank. And you'll get your MCLE announcement shortly after the program. But next, I just want to talk about our upcoming program. You could say it's our version, or not, it's the upcoming program in December 8th. You could call it the Beverly Hills Bar's version of the Abraham Accords. So today we have Osher, who you'll hear about shortly, from Israel. We have Orit, who already shared that she's, an Israeli citizen working in Beverly Hills. But next month, on December 8th, our program is called Live from Dubai to Beverly Hills. And we're going to have a presentation by Mansour Luta and his law firm, who are based in Dubai. And it's going to start a little earlier. I guess they're a couple hours later, so we're making it a little easier on them. That program on December 8th is going to start 10:30 our time, and Mansour and some other attorneys from his firm are going to be talking about very innovative programs for, quote, people of determination. And you may wonder, what does that term mean? Well, in the Emirates, as I now know, because that's where I met Mansour, I was there in September. In the Emirates, the official name for people with disabilities is people of determination. And he's going to talk about all the special programs there for those folks. He has a large law practice, but one part of the law practice is in the area that we deal with, elder law. And you'll hear about how elder law, conservatorships, probates operate in the United Arab Emirates, which, say the least, will be very interesting. So please tune in for that program on December 8th. You should be getting the announcement shortly, or if you go right on the bar website, you could sign up right now. Now I want to introduce our speaker today, Osher Felicia Haleli, who, as I mentioned, is in Israel right now. And she's going to be speaking about matters related to older people who have transactions with real estate in Israel. And we're very fortunate to have Osher, very prominent international law expert, deals in Israel and many other countries as well. And I believe I should also want to share appreciation for Jeffrey Roshba, who's the attorney, another Israeli attorney, who actually introduced me to Osher, and also made the introduction to Mansour, who we'll hear from next month. So with that, I'll turn over the program to Osher.
Thank you very much. So hello, everyone. Let's try and get this screen share started. Please let me know if there's any issue with the screen share. So I'm Osher Felicia Haleli.
Osher, sorry to so it looks like we're not getting the presentation view. Do you want to try and reset it?
Okay.
There we go. Looks great. Thank you.
Great. Okay. I'm glad we redid that. So, so I'm Osher Felicia Haleli. I am licensed in the U.S. I live and work in Jerusalem, Israel, and throughout Israel because Israel's small. And the large majority of my clients are located in Israel or around the world. And a small part of my practice are people who are located in the U.S. residents, and have assets outside the U.S. or are considered what I call global families. And I'll talk about that in just a moment. I've been practicing U.S. estate planning law for 25 years, going on 26. Someone I met today said, oh, so that makes you 12 years old. So I'm going to go with that, that I started practicing when I was 12. And in the last 15 years, I've been here in Israel, and I essentially moved over into the practice area that we're going to talk about today, which is U.S. international estate planning law. And so we're going to be dealing today with cross-border estate planning and cross-border estates. So let's see if I can get this to move on. Yes. So essentially, when we're talking about global families, what I mean when I use that term is either clients who have assets outside of the country where they reside, or they have heirs who live outside of the country where they reside, or they themselves perhaps have citizenship in another country, and which also may be taxing them on various incomes that they have. And so when we have clients who are U.S. residents but own assets in Israel, or perhaps have heirs who live in Israel, we have other issues that need to be addressed when we're looking at their estate planning. So I have found that typically the local estate planning attorneys know the local law, but they're not familiar with any of the international issues that I'm going to bring up today. And so for me, at least, it was a learning curve. And I've found over the years that it's a learning curve for any local estate planning attorney. So this would include not only the attorneys who I might be speaking to today, who practice California law and that's it, some of you may be in the international arena, and that's wonderful, but also the Israeli attorneys that you'll be dealing with. They really only know Israeli law. And so typically I'm the one who puts those two together and kind of smooths the edges between those two. So let's see what types of issues can come up. One of the things that I've noticed over the years is that we have to today, I really think that ethically we're obligated to ask our clients where their heirs reside. And that way we can start to find out more about which type of planning will be required for these clients. We want a full list of all of their assets worldwide, not just their US assets. And I think it's important for us to word our questions that way so that the clients know that we need to know if they own an apartment in Israel. We need to know if they have a bank account in Israel. We need to know if they have Israel bonds, et cetera, et cetera. And the clients won't necessarily understand our questions if our questions are too narrow. So when we look at clients who own assets in Israel, some of the things that I'll talk about today are a pour over will into a living trust. That structure has very, very severe pitfalls in Israel. It will not work. And it's not going to be a smooth transition. It's going to be very difficult for a trust, any trust, let alone a non-Israeli trust, to own assets in Israel, any assets, real estate or bank accounts. And so we'll talk more about that later, but it's very important for us to know that because we don't want to assume that what works in the US is automatically going to work in another country, specifically Israel. We need to realize that US durable powers of attorney can be used in Israel, but only in very limited circumstances. Essentially, powers of attorney are not documents in general that cross borders. And so clients need to be counseled that they need to obtain and execute Israeli durable powers of attorney as well. And I'll talk more about that. And finally, there are tax issues that we need to consider. We need to take a look at things such as step up in basis. Israel does not have step up in basis. And so the Israeli assets will not step up. Now, heirs who are living in Israel, more and more these days can get a confirmation from the Israeli tax authority that the assets that were located in the US have received a step up in basis, and therefore they can request a step up in basis from the ITA, from the Israeli tax authority, but not assets in Israel. Assets in Israel do not have a step up in basis. So if mom and dad bought an apartment in Jerusalem for $200,000, and today it's worth 1.5 million, and that's when they pass away, and that's the value at date of death. When the children go to sell it sometime later for $2 million, their cost basis is going to be the original cost basis that mom and dad bought it for at $200,000. So my suggestion to clients all the time, and in any of these types of talks that I do, whether it's before lay people or before professionals such as yourselves, is we really need to create a team. And on that team should definitely be an Israeli attorney working with you, and as well as a US CPA, and sometimes we also need an Israeli CPA. The Israeli attorney who practices who practices estate planning, Israeli estate planning, will not necessarily practice Israeli tax. Those two don't necessarily go together. We see that also in our practice in the US. Often, US estate planning attorneys and US elder law attorneys do not necessarily practice US tax law. And so we may need to bring in an Israeli tax professional, be it an Israeli CPA or an Israeli attorney, to advise us on that area and what the issues might be that are arising from the estate plan that we're planning to put into place. Of course, we may wish to consider having a financial advisor involved, particularly if the family has a financial advisor who's located in Israel. So let's start with the issue of powers of attorney. As I said before, cross-border powers of attorney are not very typical. I also mentioned before that in some instances, I've heard from colleagues here in Israel that we can try to use a US power of attorney to get certain things done, but that's only going to be very particular transactions. It's not going to be a global power of attorney that might be needed if someone becomes incompetent. Let's talk about what would happen if one of our clients should become incompetent and they own assets in Israel. Well, if they do not have a power of attorney that would be recognized as valid by Israeli financial institutions or the Israeli land registry, which is the equivalent of, for example, a register of wills, excuse me, a register of deeds office, then someone will have to apply for guardianship in Israel, in the court, in the family court in Israel. In Israel, there is a government entity called the public guardian, and the public guardian dictates to all of the guardians who are appointed what it is they need to do. They are involved in every court case where there's a request for an appointment of a guardian. Typically, there's a law in the books that says that the public guardian needs to know all of the ward's assets. I'm talking guardianship because that's what I'm used to from where I'm licensed. I know in California we're talking conservatorship, so hopefully it can be interchangeable when I'm speaking with you. And so I don't know about you, but I would prefer to avoid disclosing additional information that doesn't necessarily need to be disclosed to another government. And so if we have a power of attorney in place, there's no such disclosure that needs to be made to the Israeli government of the ward's assets worldwide. And so that's what I would prefer to be able to advise my clients. Now, I will say that the Israeli durable power of attorney, it's a new statute. It was passed, if I'm not mistaken, in 2015. And then it came into the form was available for use in 2016. So it's a relatively new law. Before this, they didn't have the equivalent of a durable power of attorney here in Israel. And the literal translation is an ongoing power of attorney. And so only certain attorneys have been trained to be able to draft and execute these documents. Typically, a person who would like to execute these documents has to be present in Israel when signing. However, there can sometimes be some accommodations made. And so this is something that should always be discussed in depth with the Israeli attorney with whom you're working. And I will say that they are expensive. They're running at least 6,000 shekels and up per power of attorney, and that comes out today to be approximately, well, close to about $1,700, $1,800 per power of attorney. It does get filed with the Ministry of Law, and it can go into effect upon signing if that's what the terms say and that's what the client wanted. Typically, it will go into effect upon a finding of incompetency, which can also be defined in the document. So many clients come to me asking, should I have one will or two wills? So because I started to talk before about how the structure of a pour over will into a living trust does not work well in Israel, it won't be able to be implemented well, either before death or after death, then we need to look at what the options are. So Israel requires probate of all assets located in Israel. It requires Israeli probate of all assets located in Israel, except for retirement type plans, in other words, that have beneficiary designations, and life insurance, Israeli life insurance. Those may need probate similar to the US if it says something like, per the terms of my will, or as the beneficiary designation, or if the beneficiary designation says per my estate. And so we also want our clients to check any beneficiary designations. Now, when might this come up for you, the retirement type plans and life insurance? If a client used to live in Israel during their working years, then they most probably have some retirement type plans and some life insurance located in Israel. And so once again, we need to find out some more history regarding our clients, not just, oh, now they live in California, but rather, where did you live before? Did you ever live abroad? If you did, do you have any assets there? Do you have any accounts there? If they're not sure or they don't think so, I would ask them to check so that we can make sure that we're thorough in our estate planning for them. So everything else in Israel, aside from these accounts that I just mentioned and the insurance, requires Israeli probate. And so if there already is Israeli probate required, my typical advice to clients, of course, it depends on the situation, is to have an Israeli will that carves out that this will applies to any assets located in Israel. And that way we know that we have a will that has been tailored for the request that will be made after death for an Israeli probate order. The wills in Israel are typically quite simple, right? What we would call sweetheart wills, leaving everything to the spouse and then leaving it to the children in equal shares. We need to be mindful of provisions in Israeli wills that are also quite typical, that if we have minors involved, or if a child predeceases, then it's going to go to grandchildren, and if those grandchildren might be minors, or if great grandchildren might be minors, etc., then the will may say that their share is going to be held until they reach a certain age. We want to note that there can be U.S. tax consequences for that if that minor is a U.S. citizen. So these are the types of things where a U.S. CPA would be helpful for us, or a U.S. estate planning attorney who is familiar with issues of global families and U.S. tax law. And the reason that I say that is because any holding of assets in a share under an Israeli will would essentially, by U.S. law, in my understanding, be considered a trust. And it would be considered a foreign trust because it's set up by an Israeli will. So it's a testamentary trust that was validated by an Israeli court, hence the Israeli probate order. And so now we have a foreign trust with a U.S. beneficiary. And that means that if not all of the income is distributed on during a calendar year, we will have throwback issues. And so in order to avoid those issues, we want to make sure that the client's Israeli will is well drafted. And so typically, I will work together with the Israeli attorney, and I would suggest that you work together with the Israeli attorney to draft the Israeli will before the clients sign it, so that we can make sure that the will does not inadvertently incur additional U.S. tax. Please note, and this is, I think, a very big deal, there's no such thing as joint with right or survivorship in Israel, okay? Anything that is owned by joint owners is essentially joint tenancy. And so wife owns half of a house and husband owns half of a house, even though it's owned by husband and wife, that is, according to Israeli law, only joint tenancy. So upon wife's death, her half will go will be bequeathed according to the terms of whatever we use for that, whether it's an Israeli will or a U.S. will, et cetera, et cetera. It will not automatically go to the additional owners of that home. So I've spoken about a bit about how trust ownership doesn't work in Israel. Let me explain that a bit further. So I don't fully understand this, I will admit, because I've been brought up in the U.S. trust world, and in Israel, a trust is not an entity. Trusts are defined and codified in the Israeli tax law part of the code. And so it's a tax status essentially. And so because they're not considered an entity in Israel, whether it's a US trust or any other trust, then they can't really own anything. And so we get more into it looking like agency ownership than an entity owning the asset. And this is true for Israeli financial institutions. It will be very, very difficult to retitle a bank account or an investment account in Israel in the name of a trust. And then when we talk about the land registry, I have heard stories where it has taken upwards of 4 years after requests have been submitted to try and register a piece of land or an apartment or a home in Israel in the name of a trust. And so it just becomes administratively untenable. And so my recommendation is to try and avoid trust ownership wherever possible. When we're dealing with high net worth clients, then we want to deal with the right Israeli estate planning attorneys, because they will know how to best establish a trust in Israel. There are ways to do it, but the typical US ways are not the way to do it. Let's talk about a different aspect of trusts and Israel. So if we have a client who's living in California, but some of their heirs or an heir reside in Israel, and we have a structure in place of a pour over will to a living trust, and perhaps we have other trusts in place. Perhaps we have irrevocable gifting trusts, perhaps we have some grats in place, et cetera, et cetera. We need to take into consideration, once again, I'm going to emphasize this point, that the heir resides in another country, because Israel has tax laws on the books that will tax those US trusts the moment that that beneficiary is a current income beneficiary. And it will tax not only that beneficiary's share, but the entire trust. And so it is extremely important for us when we are starting to discuss estate planning options with our clients, or if we have a client come in who would like to review their estate plan and they've had comprehensive estate planning implemented in the past, to start asking again, where do your heirs live? And are they going to remain there? You know, maybe they're in Israel for a year. Okay, so perhaps we don't have to do any special planning because of that, depending on the client's health, et cetera, and the other circumstances. But if the heirs have moved to Israel and they're planning on remaining in Israel, then we need to get good Israeli tax advice with regard to any trust structures that are going to name these beneficiaries in the future, or have them as current beneficiaries now. So as I wrote on this slide, my typical recommendation for clients who are living outside of Israel but have assets in Israel, especially US resident clients, is that they have their US estate plan in place. Perhaps we need to tweak it some for reasons that I just discussed with regard to heirs who might be residing outside of the US, and we have some tax issues that we need to consider in that regard, Israeli tax issues. But with regard to the Israeli assets, I typically suggest, again, we have to take a look at the circumstances of each family, that these clients have Israeli wills prepared for the Israeli assets and Israeli powers of attorney prepared, so that we can also plan for incompetency. So let's move on to some of the tax issues. As I stated before, we have an issue in Israel with regard to no step up in basis. This is an issue that's a little bit more broad than what I brought up before. So we have one issue, which is we need to take into consideration the fact that any assets that are located in Israel will not have a step up in basis. That said, with regard to real estate, and I did give this example before, and so there can be a special discount on the capital gains tax on real estate. In Israel, there's a particular type of tax that's carved out for capital gains tax on real estate. And people who are heirs and they are selling the property can get a special discount. Now, if they inherited that property from a trust, they might not get that discount. So once again, these are important issues to discuss with the Israeli tax professional. With regard to securities in Israel, with regard to ownership of a company in Israel, with regard to any other capital gains tax possibilities, we need to be very, very mindful that there may have to be significant tax planning considered and options considered because there's no step up in basis. In addition, we want to consider the issue of perhaps a family having heirs located in the US and some heirs located in Israel. Perhaps they have heirs located in other countries around the world. I'm going to deal with those too. So when I have clients who are going to be leaving some of their estate to their heirs located in the US and some to heirs located in Israel, we need to take into consideration, or at least I offer to the clients to take into consideration, the fact that the US resident heirs will receive a step up in basis on all assets outside of Israel, at least the US ones, depending on whether they own assets in another country. That would be the issue for that country's tax laws. So we'll talk about US and Israel. And the heirs that are located in Israel will not receive a step up in basis for their US assets on the Israeli tax side. So let me give an example for that. If a client comes in and they have a son living in the US and a daughter living in Israel, and let's say the son and the daughter each inherit 100 shares of Apple stock, okay? And when the US resident son goes to sell his 100 shares of Apple stock, that he will have a step up in basis and only be required to report that on his US tax return. The daughter who lives in Israel, who had received also 100 shares of Apple stock, when she sells her shares, she needs to report it in Israel as well as in the US. She'll have a step up in basis in the US on her return, but she will not have a step up in basis in Israel on her return. So once again, one of the options that we have that I mentioned before is that upon the client's demise, if they were US residents at the time, the Israeli heirs can at that time immediately, so they're not yet necessarily selling whatever they received that's located in the US, but upon the demise of the testator, the heir can appeal to the Israeli tax authority to receive a step up in basis then and there. And so that's a very important planning tool to know about. There's talk constantly, as we all know, of anticipated US tax reform over the last few years. It's died down a little bit with the elections being tomorrow. Good luck to everyone. And so clients are constantly calling me and asking me, you know, what's going to happen, particularly clients who are located outside of the US. And we need to keep our clients informed of whatever it is that we know. The last point on this slide is very important. We need to keep in mind that at times the US is going to consider a transaction or a gift, etc., a tax event, a taxable event. And at times Israel is going to consider something a tax event, and that's not necessarily going to occur in the same year. And when it doesn't synchronize in the same calendar year, there is a very high risk that a client will pay tax twice. There is an income tax treaty between the US and Israel. There is not an estate tax treaty between the US and Israel, because Israel does not have an estate tax. It does not have an inheritance tax, But once again, it doesn't have a step up in basis. And so we need to be mindful that we want to make sure that any taxation that's happening in one country is going to happen in the other country in the same year. So we need to be as familiar as possible with the income tax treaty between the US and Israel. The way to do that, in my experience, is to make sure that as part of our team that I mentioned before, we have a US CPA who is very familiar with that income tax treaty. I have not found many US CPAs who are stateside who are familiar enough with the treaty to be helpful in advising on these issues. Most of the advice that I get is from US CPAs who are living in Israel and are very, very familiar with the tax treaty. So one of the questions that I get asked by clients is, should an heir who resides in Israel apply for US citizenship for their children? So I don't know how familiar everyone is with the immigration laws. I am somewhat familiar with US immigration laws, but basically there are times that a parent can apply for citizenship for their children on their own, and sometimes the parent needs the grandparent to apply for citizenship for the grandchild. And so often when the latter happens, I get consulted when we're talking about higher net worth families. And so the considerations that I bring up to these families is what is the net worth of the grandparents and the children? What is expected to transfer on to the grandchildren? Because if we're talking about a high net worth family and there's a possibility that a grandchild is going to be inheriting a significant amount of money, perhaps we want that, or assets. Perhaps we want those assets or those funds to leave the US tax application. And I would say that could be very helpful. And so we need to do, significant planning in these cases so that we can advise our clients well. Sometimes the heirs can be somewhat short-sighted in getting excited about being able to have a child tax credit for every child until age 16. And we need to be careful with that, because we may actually be doing longer term, I wouldn't say damage, but risking, exposure to additional US taxes where we could have saved that. And so if we're talking about net worth that is located in the US, perhaps there's no issue here because it's located in the US anyway. But if there's a possibility that we could be taking a look at either funds that could leave the US or trusts that could have non-US citizens as their beneficiaries, this could be helpful with regard to tax planning. So a very common phenomenon that I run into with clients who are in the US and their children are in Israel is that a US citizen might marry a non-US citizen. And so what we need to consider in that case is that the US citizen who's married to a non-US citizen has some kind of stranger or more peculiar US tax laws that will apply to them. And the clients are typically completely unaware of these issues, both the children and our clients, the parents. And so in these cases, what I call mixed marriages, I typically talk about first to die and second to die. It's difficult wording to use, but it's important. If we're talking about an heir who already owns assets both in the US and in Israel, then we will want to have a conversation with them about, obviously our clients are the clients who are located in the US, but I think it's important to inform them that their children may need some additional tax advice, and that what the tax advice that our clients are receiving, who are both U.S. citizens, officially married, living in California, is not the tax advice that's going to be applicable to their child who resides in Israel and is married to a non-U.S. citizen. In a moment, I'm going to talk about the child who resides in Israel and has a common law spouse who is a non-U.S. citizen. So, when I'm having a conversation with the heir, which will often happen, the parents will say, well, can you also advise our children? And obviously there can be some ethical issues around that. And you know, I remind us all to look into that and make sure that we dot every I and cross all the T's. And so when I'm sitting with the heir who is married to a non-U.S. citizen, I will have to talk with them about, well, if the non-U.S. citizen passes away owning some assets in the U.S., then there's no estate tax as long as the heir to those assets is the non-U.S. citizen's U.S. citizen spouse. But if the U.S. citizen passes away, so first of all, they only have one lifetime exemption, and there's no possibility of portability. And so we need to keep that in mind. And second of all, the non-U.S. citizen now has inherited from the U.S. citizen and owns assets in the U.S., perhaps, that are valued at more than $60,000. And $60,000 is the exemption from U.S. estate taxes for a non-U.S. citizen. And non-U.S. citizen, non-resident. And so I need to sit down with that couple. I typically try to advise them that they really need to think about whether they want the non-U.S. citizen spouse to even inherit from the U.S. citizen. Should we set up a trust in the U.S. for these assets to benefit perhaps the children? Are the children U.S. citizens? Are they non-U.S. citizens? In other words, our clients' grandchildren, right? And so there are issues here that we need to take a look at. Another issue here is, should the U.S. citizen inherit from the non-U.S. citizen spouse if there's a possibility that their joint net worth is going to be more than the lifetime exemption? So perhaps the non-U.S. citizen should, in their Israeli will, leave their assets to the children instead of to the spouse. And so we need to look at all of these issues. And of course, together with any tax issues that could come up on the Israeli side and any estate planning issues that could come up. So we want to make sure that we have this whole team that I talked about before working together in these cases. So in Israel, there is common law marriage, and we need to be mindful of that. In as short as just a few months, a couple could be established as being in a common law marriage relationship, according to Israeli court opinions, and they don't even have to be living together in order for that to be established. And so we want to make sure that when we're dealing with any heirs, you know, would it be a good idea for this heir to have a more ironclad trust share, for example, if there's a possibility that they are in a common law marriage? In addition, Israel is a community property state, and I know that you're all familiar with those terms, being in California. And there have been Israeli court opinions that have, in divorce cases, enabled a divorcing spouse to claim rights to a share of a trust that was being held for the other divorcing, the other spouse in the divorce, who's a beneficiary of that trust. And so we want to be very, very careful with our wording of the trusts. And once again, we want to consult with relevant Israeli counsel so that we can make sure that asset protection is in place if needed. One interesting aspect of community property here in Israel, and I'm sorry that I don't know enough about California law to know if this is something that occurs in California as well, is in order for a spouse of a decedent to claim half of the decedent's solely owned assets upon death, that surviving spouse has to go to court to assert the claim. When they assert the claim, there shouldn't be any issue. Then, you know, it's not a contentious case, but they do need a court to make a determination that the two were married, that they were married at the time of death, and that the surviving spouse is in fact entitled to their half. So this has been helpful in some estate tax cases that I've had to deal with, because when the spouse has asserted their half, their rights to half, then we've been able to reduce some of the shares on the estate tax return. When the decedent spouse had not essentially asserted their rights to half of the surviving spouse's assets, we were able to make a claim that they didn't have rights in any solely owned assets by the surviving spouse. Now, of course, that's an impossibility because they're no longer alive to be able to assert their rights. But basically, because of that, we were able to make that claim. Okay, so I have arrived at the end of my presentation, so it's time now for some questions and answers. Terry, did you want to?
Sure. I'll start with the first question from Mitch Miller. Hi, Mitch, out there in the audience. Does Israeli probate apply to Israeli real estate owned by an entity such as an LLC, Israeli or US LLC? Is there a US LLC equivalent in Israel? I think it may be called company. I don't know what it's there, but I guess that Mitch's question is, if someone has shares in a company, is that part of Israeli probate, or is that part of the probate in the state where the person resides?
Right. So that's a great question. I'm going to try and answer it piecemeal. With regard to the various companies that exist in Israel, there is a corporation, which is a limited corporation, but there's no such thing as a limited liability company. The limited corporation has the double accounting that's required, and for tax purposes, income tax purposes, there are family companies in Israel that are pass-through companies, but they need to be owned by family members. And so there's a much more limited options with regard to the types of companies that exist in Israel. Now, if it were an Israeli company that owned real estate, the Israeli company, the shares, the ownership of the shares in the Israeli company would have to be probated. Those cannot pass on to the heirs without an Israeli probate order. There's no such thing as survivorship provisions in companies such as we might know in the States. If we put provisions into an LLC agreement or into a partnership agreement, then we don't necessarily need probate for some of that. I'm not talking about California law, I'm not sure, but in other states. In Israel, we don't have that option. Now, if it were a California LLC that owned Israeli property, first of all, I'd love to see that happen. I'm not sure that could happen, to be honest. I think that might be one of those difficult structures to implement. And if that could happen, Israeli law is very clear that assets in Israel can only pass on with an Israeli probate order, period. It doesn't matter that there have been other probate orders elsewhere or that there are survivorship provisions within, an LLC, a California LLC.
Okay, sure. Just to clarify that, so if someone has a company, whatever kind of quote unquote company they have in Israel, family company, Joe owns is a shareholder of the family company. Joe dies. Aren't those shares, if Joe lives in California, are those shares just California it's just personal property that's not subject. You need the probate order in Israel anyway for shares of a stock in Israel, even though let's say the real estate is owned by the entity, not the person, but the shares themselves need some type of probate order for those shares to pass from the parent to, let's say, the child or whoever it is.
Yes.
Okay.
Yes, that's been my experience.
Okay. Let's see. The next is a U.S. couple living in Israel. Okay, has a revocable trust set up for U.S. assets. So it's like U.S. couple, they have their assets here. They have standard garden variety, I guess, revocable trust. Are there foreign tax credit concerns during the lifetime of the settlers resulting from U.S. income generated by that trust? I'm not sure if maybe do you understand that question?
Yes.
Osher? Okay.
Yes. So I didn't talk in this talk about clients who are residing in Israel. Clients who are residing in Israel, we would be talking about a totally different ballgame. Okay. Depending on how many questions we have, I'd be happy to talk a little bit more about that with our remaining time. I was talking about the scenario where we have clients who are residing in California and they have assets or they have heirs that are in Israel. And so if I'm going to flip for just a moment to answer the question, a U.S. revocable living trust and the settlors are now residing in Israel, right? So it's on the settlors, it's a grantor trust, it's on the settlors' social security number. It will be the same in Israel. So in Israel, they will be reporting all of the income on their Israeli ID number. Now, I didn't go into this, but anyone who moves to Israel, almost anyone who moves to Israel, particularly people who have never lived in Israel before, receive a 10-year exemption from Israeli tax on any passive income. And so if they have assets in the US that are generating passive income that are part of their trust or not part of their trust, then they won't have to pay Israeli tax on them for 10 years and they don't have to report them for those years. But if we're not talking about people who are within their 10-year exemption, then it would be taxed as though it would be taxed to them. It has, just like in the States, you don't report special for a living trust. You just report it on your regular tax return under your social security number. So same in Israel for that. Now, would there be foreign tax credits? Yes. Just like it would be taxed to the individual, it's the same. It doesn't matter in that case.
Okay, next question is, are there any income or reporting issues for a trust beneficiary residing in Israel, but the deceased settler and all the property is 100% in the United States?
Yes.
And on top of it, I think there are reporting requirements in Israel. Yes. So you reside in Israel. Somebody died in the United States. They have all their property in the United States. But when you, as someone who's in a beneficiary of the trust, inheriting it directly, held in trust for you, there are reporting and income requirements in Israel.
Yes. And so I will tell you that I had a meeting today with an Israeli CPA, not US, Israeli CPA, with whom I have worked for, I don't know, more than a decade on various cases. We were just catching up and he was telling me that trustees around the world are quitting because they don't want to have to report in Israel. And then it's difficult for some trusts, these are corporate trustees, and then it's difficult for a trust sometimes to find corporate trustees to replace them who are willing to fulfill all the reporting requirements to Israel. So my strong recommendation, hopefully you'll come out with a bunch of stuff that I said today that's new for you that you're going to try and internalize. Please internalize that if you have clients who have trusts, U.S. trusts, and they are U.S. settlors of those trusts. They are currently living in the U.S. and they're not planning on living in Israel anytime soon, but they have heirs or beneficiaries of those trusts who are residing in Israel. Those trusts must be reviewed by an Israeli tax professional. Please feel free to contact me. I'm happy to refer you to the right people in Israel who I know are competent. I don't receive compensation for the referrals, but they have to be reviewed because we want those trusts modified during the lifetime of the settlor, if possible. If the settlors are no longer competent and it's going to be difficult to modify those trusts, well, then we would like those trusts, if possible, decanted, or if there's a trust protector in place who can modify the trust, et cetera, et cetera. Because we want this done before that beneficiary becomes a current income beneficiary. If you have clients who have trusts that already name a current income beneficiary who is an Israeli resident, here too, you would like to get or advise your clients to get good, competent advice from an Israeli tax professional as soon as possible, because they're supposed to already be reporting in Israel, and we don't want them to incur any additional penalties above what they're already going to incur.
Osher, just a follow up on what you just said, it about trustees. So even though the question was a reporting requirement for a beneficiary, are you saying the trustee, because they're all the corporate trustees, individual trustees, they're all here, all of a sudden you see a beneficiary of the trust who is an Israeli citizen, resident?
No, resident has to be resident.
Resident, even a resident, that trustee has additional reporting requirements.
Yes,
so
the
that trustee
does.
needs to hire some counsel, tax advisor, something in Israel so that the trustee is fulfilling its reporting requirements.
Yes.
Okay. And I think even as a follow-up is an augmented question, the one that was just asked, because I don't see another question there. When the beneficiary in Israel is a minor, were you saying before, and it's quote unquote, the money does not get held, is held for the person, my understanding would have been, oh, there has to be a guardianship of some kind in Israel. But is it quote unquote held in some way? And did I hear that you said maybe there's a designation of this trust as a foreign trust, which is foreign trust, we know, anybody that's touched that at all, that's usually, that sends off major alarms. Is that what you said? That you have somebody has a trust, a minor is living in Israel, can't get the money now for whatever reason. Somehow this is turning into a foreign trust?
Okay, so I was talking about a testamentary trust that's set up by an Israeli will. And so
Okay.
if we think about it, if we think about the mirror of it, right, if we were in the US and we had a California will that set up a trust for a minor, right, we would know that that's a testamentary trust, and it's obvious, and it's a US trust because it was set up by a US court. The assets are all located in, let's say, California, the trustees located in California, right? That's clear to us. So we're going to take it back to Israel. And so what happens is, if we have a client who has an Israeli will that says in it, if any of my heirs have not yet reached age 25, then hold the assets. It won't say in trust, it'll say in the estate for the benefit, right, until they reach age 25. So it doesn't even use the word trust. But from my research under US tax law, it will be considered a trust because essentially it's being held for the benefit of this heir, which is really a beneficiary. The executor is named as the person who can hold this, or sometimes they do name a trustee, they call it a trustee, who will hold these assets until the minor or adult has reached age 25 or whatever it is listed in that will. And the will is subject to the jurisdiction of an Israeli court, not a U.S. court. And so under U.S. tax law, a trust is a foreign trust if it has a either non-U.S. citizen non-U.S. citizen trustee, and if that trustee is not subject to any U.S. court jurisdiction, and if it's already subject to Israeli court jurisdiction, it's certainly not going to be subject to U.S. court jurisdiction.
It's a major issue among other issues you mentioned. And I see we're at an hour. Wait a minute. Some came in. We've got one more from Mitch here. Mitch,
Sure.
We're going to give you another question here before we wrap up. Would it be helpful to have a U.S. bank with offices in Israel or an Israeli bank with offices in the U.S. be a trustee?
So good try. What happens is, in my experience, for example, Bank Leumi is a major bank in Israel and it has offices in the US, but Bank Leumi in the US is Bank Leumi US or Bank Leumi New York or Bank, etc. So it's a separate entity. And so there's no crossover between the two of them. And to the best of my knowledge, I believe there are 2, maybe 3 U.S. financial institutions that have offices in Israel. And again, they're not really offices in Israel. They're a subsidiary of the U.S. financial institution itself. So I think we have Citibank here and Chase, and we used to have Oppenheimer, if I'm not mistaken, which is not a bank, but and so they really, and they only take private clients with very, very high level of assets by them. So I don't think that that's going to be a helpful option.
Osher, thank you so much. The presentation was eye-opening. I think that's a good description of it, because certainly people are not, attorneys, CPAs, certainly clients are not really aware of these issues, I don't believe. So thank you so much. Thank you for everybody in the webcast audience. Plan to see everybody, I guess, December 8th for our next program from Dubai. Okay. Bye, everybody.